Okay, hi everyone. Thank you so much for joining us. I am Michelle Morris from Consolidated Planning Group. We've got Melissa Donovan with us today. Thank you so much for being our presenter today and being with us to help us learn more about guardianship and the process and what it all entails and how it works. Before we get started, I want to go over the rules of the road, if you will. If you've been here with us before at one of our webinars, you probably know, but I wanted to let you know that since we're in webinar mode, we cannot see you or hear you. So you can put any questions and comments that you have in the chat box. I will be monitoring that, and we're going to get to as many as we possibly can. This webinar is being recorded, so we're going to send it to you later on today, along with a copy of the slides. And if you're listening on our podcast and you would like to have a copy of the slides, you can email us. The address is contact@cpgcares.net. Like I said, if you're on our podcast. So just who we are a little bit real quick. Next slide, Melissa. Consolidated Planning Group. We are located just outside of Houston in the Sugar Land, Texas area. We work all across Texas and all across the United States. We are first and foremost a financial planning firm, but we focus on special needs planning. We have over 30 years experience with insurance and financial services, members of the MDRT $1 Million Round Table. We are members of the Special Needs Planning Academy and nationally certified as Social Security advisors. So we do everything that a traditional financial advisor would do, but we add on all of the special needs planning services as well. Next slide. People come to us for help with protection plans like life insurance or income protection, lifetime care plans for their families and for their loved ones, transition planning, ABLE accounts. And, we really seek to educate and advocate for families who have a special needs loved one, because we know it adds an extra challenge when it comes to all of the nuances and rules and regulations of where you can have your money and how you can save money for your loved one, and the planning challenges of having kind of a third bucket of money that needs to be filled up for your loved one. You are definitely in the right place, because there are over 263,000 financial advisors across the U.S., according to the Bureau of Labor Statistics. 263,000 of them, but less than 0.1% of us focus on special needs planning. So thank you for being here today. Next slide. This is my last slide for now. I'll talk a little bit more later, but just things to think about and things that we help with. Developing that future care plan earlier in your life helps you, sleep a little bit better at night, helps you plan for the future and make a bigger impact long term. We want you to think about what's going to happen after high school, what educational and vocational options are out there, as well as what transition programs, long-term care, partial care, residential communities are out there, because the waiting lists can be quite long. And to make careful consideration before you just name a sibling as a future caregiver. So those are a few top tips for you when you're thinking about special needs planning. Next slide. I just want to introduce, and we've put all of our contact info in the chat box. So again, thank you for being here with us. Thank you, Melissa. We should be here for about an hour. And if you have questions, put them in the chat box, please. Take it away, Melissa.
Thanks, Michelle. Hello, everyone. My name is Melissa Donovan. I'm a certified elder law attorney. Here I work at a firm in Austin, Texas Trust Law, formerly the Wewell Law Firm. I know when you hear the term certified elder law attorney, it probably makes it sound like I just work with old people. That's not what that means. It actually means that my specialty is dealing with areas of special needs concerns, dealing with government benefits, long-term care planning, special needs planning, things of that nature. So my main focus here at the firm is special needs planning and Medicaid planning, in addition to general estate planning, guardianships, and probates. What we are here to talk about is guardianship, which is one of those things that a lot of people think they need when they don't need it. And then there are some people who do need it who never really think about it. So that's why you're all gathered here today to probably learn a little bit of information about, what is guardianship and do you actually need it for your child, your sister, your mom, whoever it is that you're concerned about at this moment. So as per usual, when you've got an attorney speaking to you, we've got to do the obligatory disclaimer. This is meant to be educational, but you're welcome to contact us at any time for actual advice. So let's kind of chat baseline and what a guardianship is. So guardianship is where you are going to court and you are having a court appoint you to, the way I like to explain it, continue to be your child's parent when they turn 18. Because that's essentially what you're doing. The issue is that under the law, when someone turns 18, they are legally speaking an adult. And if there's a situation where you've got an individual who does have some incapacity, I've had guardianships from all sorts of different conditions. A lot of the time when people are talking about these things, yes, autism these days is a big one that is discussed. You've got Down syndrome, you've got cerebral palsy. I've had all sorts of different conditions, and there's a range of things that can happen. Some people need guardianship, some people don't. But what you are doing with guardianship essentially is saying, my 18-year-old, or if you've waited a little bit, my 22, my 26-year-old, they don't have the ability to make these decisions. They cannot care for themselves. It is dangerous to allow them to do so. That's where you would end up in a situation where you might need guardianship. Now, regardless of what Netflix and Britney Spears and celebrities want you to believe, it actually is quite difficult to get guardianship, especially here in Texas, because there has been a big push to what you see here, this term of less restrictive alternatives. Basically, what that means is we don't want to have a court involved in your life. I'm guessing you probably don't want a court involved in your life if it's not absolutely necessary to do so. So less restrictive alternatives are going to be things like thinking about, can the person sign a power of attorney? Would a medical power of attorney and a financial power of attorney solve the problem? And if they would, does the person have the actual ability to understand what it means to sign those documents? It can also be things like, can we do a joint bank account? So there's lots of things to think about in less restrictive alternatives. The big thing that we'll talk about later a little bit that I get a lot of questions on, because it's kind of like the hot new thing in the last few years, is what's called a supporting decision-making agreement. So we'll get into that a little bit later on as well. So there's all of these different alternatives where if you can avoid a guardianship, trust me, you want to. So when you're raising a child who does have any special needs, no matter what the condition is, these are some of the things you need to think about. So you need to think about, what are the alternatives to guardianship? Or if there aren't any available, what do we need to do to get guardianship? A big thing from my perspective is that bottom one right there in your support team. Not only who is the family and the friends around you that can physically support you day to day, but people like Michelle and Allison. Do you have a good financial advisor who knows what they're doing in dealing with special needs concerns? Do you have a good CPA if you've got a special needs trust, which is another issue? Do you have a good attorney who knows how to direct you to do things like your estate planning, dealing with Social Security, dealing with Medicaid? So it sometimes does actually take a village. And this is kind of what you need to think about as being your village. All of these people that are going to help you to get everything that you need within your toolbox taken care of. So this goes back a little bit to what we were talking about earlier. Do you really need a guardianship, and when? When your child turns 18, you legally speaking do not have the right to make decisions for them any longer. And you don't have the right to talk to their doctors. unless their doctors technically break the law to talk to you. Okay, now, granted, I'm a very practical person. There's the legality of things and there's the practicality of things. Most people, if you have been working with the same doctors, the same therapists, the same school people for years and years and years, it's not like the minute your kid turns 18, they're just going to say, nope, sorry, can't talk to you. Technically, legally, should they? By the letter of the law, yes. However, most people are reasonable. They give you a chance. To put it in perspective, I have some clients that we start the guardianship process as soon as possible, which is about 6 months prior to the 18th birthday. I have some clients where we don't actually get guardianship until the child's into their 20s, because they don't come to see me until then, because they've had decent luck going through with the doctor since then. Again, there's the legality of that, but there's the practical reality of how some doctors work in things. And that's usually the concern. What is typically going to tip the scales towards guardianship when your child doesn't have the ability to sign and make decisions for themselves is going to be that moment where the doctor stops talking to you. And that's typically where someone is going to contact someone like myself and say, hey, what do I do? Then you need to start thinking about this guardianship stuff, okay? But the key thing to remember is, legally speaking, as soon as your child turns 18, your right to make decisions for your child is over without further actions being taken. So some things to think about when you're going down and considering this road of guardianship. The first thing is figuring out, okay, what is the actual concern? Is it, like I just said, my child's doctor is suddenly not talking to me anymore? What do I do? How do I get the doctor to talk to me because my child's not able to? Sometimes even with, non-special needs kids, they just don't want to talk to the doctor. That's a whole nother conversation. That's just a HIPAA. Got to get your kid a HIPAA. But the concern is, first and foremost, what is the problem that you're facing? What's preventing you? What is it being prevented from? Okay, can you not talk to the doctor? Can you not deal with the school? Are you afraid for your child's well-being because maybe they are a little bit more likely to be taken advantage of and manipulated? We need to make sure that that's not going to happen. When you get past that, then you need to think about, is this a temporary issue, or is this something that's not going to go away anytime soon? And I always tell clients, take that word temporary with a grain of salt. It doesn't mean that it's either temporary or 100% permanent. It means, is it temporary in the sense of, this is something that's fleeting. It's going to happen. There's an imminent issue, but it's going to go away, this concern, within maybe 6 months, a year, 30 days, however long. It's a kind of one-time thing that has to be dealt with. Or is this something that I'm going to have to be dealing with ongoingly? Maybe it's over the course of a couple of years. Maybe it's the course of 20 years, who knows? But the one thing I always like to impress upon clients is, even permanent guardianship is not permanent. It is something that is reevaluated annually. So sometimes that can be a little scary for clients, in my experience, where they think, well, if I'm going to get a guardianship and I'm taking away my child's rights, this is a forever thing. Nothing is forever. Everything is reevaluated. And we'll kind of talk a little bit more about that as we continue to get into things. So then when we get into that scenario, okay, we know what the concern is. We've identified if it's something that's fleeting, temporary, or a little bit more permanent. Then, are there other resources available to help me? So are there less restrictive alternatives that we can do? Can we do a supported decision-making agreement? Can we do bank accounts that are going to be joint, so you still have some control over what the child has access to? There's different concerns, there's different resources. What community actual organizations and help with individuals do you have available to you to try to put things in place, maybe short of having to go to court and take all of the rights away from an individual? And that goes to your team that we were talking about earlier too. Then you need to think about, what are the actual limitations that your child has? So sometimes it's very, very clear that an individual needs a guardian in place. If they have no ability to communicate, they have no physical ability to take care of themselves, it is very clear that they don't have the capacity to sign documents, to make decisions for themselves. That's really clear. You're going to have no other options but to get a guardianship, so someone can do what that individual would otherwise do for themselves. But maybe it's a different scenario. Maybe it's that there are some things they cannot do for themselves, but other things they could. So we'll get into that too. What rights are you actually taking away, and do you have to take all of them away? Those are things to consider as well. The biggest thing is what kind of capacity does your child have? Meaning, does your child have the ability to consider what it means to sign things like a financial power of attorney, a medical power of attorney? Do they have the ability to understand, I am giving mom, dad, sister, whomever, the right to tell my doctor, if I can't tell them what to do, what the doctor can do in that situation? Or I am giving mom, dad, whomever, the ability to help me manage my bank accounts, to help me pay my bills, to talk to Social Security for me. Those are the things that you need to consider. If they have the ability to do those things, then you do not need to get a guardianship, generally speaking. So there are a few different types of guardianship. So guardianship breaks down to basically two different arenas. And in other states, in Texas, we refer to both of them as a guardian. So it's a guardian of my person and a guardian of my estate. In a lot of other states, you'll hear the term conservatorship. So if you are familiar with the Britney Spears case, you are familiar with the term conservatorship. In most states that use that terminology, conservatorship is the equivalency of our guardian of the estate. It's who is managing the assets. In many scenarios, particularly with children who are just turning 18, we can avoid that completely here in Texas. And if you can avoid it, you want to avoid it. And we'll kind of talk more about why you want to avoid that in a little bit. But guardian of the person, that's what I was saying earlier, where I tell clients all the time, that is allowing you to continue being their parent. Guardian of the person is what's allowing you to continue to make medical decisions, determine where they live, assist and determine where they're going to school, avoiding situations that could be medically or health-wise detrimental to them. It's you being parent still. That's really the easiest way to explain it. Sometimes it's required to do both. Okay, so sometimes you just need a guardian of the estate. Sometimes you just need a guardian of the person. Sometimes you need both. Okay. Where you would need both is when you have an individual who does have an estate, and an estate is a very simple concept. They have money, they have assets in their name. Now, typically, if there's a bank account and that bank account is below $2,000, you still generally don't need to get in a guardian of the estate situation. There are other ways to deal with that. But if, let's say, someone had already been working, so this happens too. Not everybody is born incapacitated. Okay. So we had a case one time where client had healthy children, adult, worked, really bad car accident when the son turned, he was in his late 20s, massive brain injury, never able to work again, could not do anything for himself, didn't have anything in place. Those are scenarios where he's already worked, he's already developed assets, he's got bank accounts, he's got a car, he's got things in his name. You are going to need to get a guardian of the person and a guardian of the estate. But like I said earlier, with most, when you're dealing with your underage child turning 18, it's really easy to not have money in your child's estate. And you want to avoid that as much as you can. If you have a child who is a teenager and you are getting close to this, you want to make sure that you take and get any money out of your child's name that you can, if you are really thinking that you need to go down the guardianship route, because you want to avoid having to do a guardian of the estate in addition to a guardian of the person. There's a very big difference in court involvement, time and energy between doing a guardian of the person and a guardian of the estate. So if you can get that money out, if there's a small amount of money, and make sure you tell, grandma and grandpa and aunts and uncles and all that, don't give money to Johnny, then you can avoid that guardian of the estate. Keep it simple with a guardian of the person. Now, temporary guardianship. Temporary guardianship is something that's done when there's an imminent danger of something. So temporary guardianship doesn't necessarily mean that we need a guardian put in place for the long term. Okay. So if I, let's say, had a massive accident, like I was talking about my client's son. So if there's a really bad scenario where for a very brief moment, something needs to be done and something needs to be done quickly, that's where you're dealing with a temporary guardianship. Temporary guardianship doesn't mean like, oh, I'm getting guardianship for a couple of years and then it's over. That's actually a permanent guardianship. Okay. But a temporary guardianship is there's an imminent danger of something occurring that's either going to be detrimental to the health and safety or the financial assets of that individual, and it needs to be dealt with in that moment. Okay. So that's a really different scenario than what most people that I work with in guardianship scenarios are dealing with. So I think we had a question come through. If you
have one question, Melissa, if you would like to address that, can we have an account with both of our names over it go over $2,000?
Yeah, so that's going to be, if you have a joint account, that's going to be a lesser restrictive alternative. The court's going to want you to use that where you can. Okay, so if there's, let's say, $5,000-$10,000 in a joint account, you still have access, you still have some managerial control over it. Generally speaking, you're going to be able to avoid that guardian of the estate in that scenario as well. So I mentioned earlier that when you get guardianship, you are literally taking away the rights of the individual that you are getting guardianship over. Also, permanent guardianship is not permanent. It is something that you are going to have reviewed by the court annually. So to give you an idea of what that looks like, when you apply for guardianship, you put in your application to the court, there will be a hearing. Now, I tell clients all the time, this is my line. This is not Law and Order, and I'm not Jack McCoy. It is generally a very straightforward, friendly scenario. It can get a little bit testy if there are contest issues. Like, let's say there was divorced parents and mom and dad are fighting over who's going to be guardian. That could be different. But if you are dealing with a pretty straightforward, I want to be guardian for my child, no one's contesting it, everyone is on your side. It is not that scary. I know it's scary for a lot of people who they're not used to going to court. They're not used to being in front of a judge. And most of us do think of, we think of Law and Order and all these things. It's not that difficult. It's not that scary. People are on your side. Okay. So once you have that hearing, you will get your letters of guardianship. Okay. So those guardianship and those permanent permission slip that you get, you have to get them renewed every year. What that means, generally speaking, is that the court has a form that you are going to fill out. It is basically an annual report to the court about how your child's doing year to year. Typically, you need to fill that out, get it back to the court within 60 days of the renewal date. So if I got guardianship on January 1st, about November every year, I need to start thinking about, do I have that form filled out, and get it to the court. So if at some time in the future, I'm filling out that annual report and I'm able to say, my child has improved to the point where they don't need this anymore, then the court's not going to renew your guardianship for that year. So that's why I say, even though it's a permanent guardianship, it's really not a permanent. You have to renew it every year. You'll get new letters every year from the court, and that's what's going to allow you to continue acting. And so this gives you, and I know I did see a question in the chat asking, does the guardianship end, and do parents have the right to have to renew it yearly? Great question. You thought before I spoke. Now, in terms of the rights that are being taken away, this gives you a rundown of the things that, generally speaking, you are taking over as guardian. I don't like to use the term. So the legislation, the statutes, the court, they use the term ward. From time to time in this presentation, you may hear me use it just out of necessity, but I really don't like using that term. But your child, you'll hear me refer to this person as your child, because that's, generally speaking, who you're dealing with. So you're taking away their right to vote, generally speaking. They're not going to be able to get a license and drive, which for pretty much all of my clients is necessity. They can't choose where they live. That is left up to you. Again, if you just think through it, it's all these things that you've been doing for years as a parent anyway. They don't get to choose their marriage. They don't get to own firearms. Any business and managerial matters, financial matters, medical, dental, excuse, all of those things you are still doing for them. Guardianship of the person, like I was saying earlier, deals with those medical and personal decision-making choices, housing, etc. So this kind of gives you a rundown of what rights you are taking away and you are taking over the responsibilities for. So kind of think about it that way. For every right you take away, you are taking on that responsibility yourself. You are stepping into the shoes of your child. to make those decisions for them. So you do have certain duties because you are getting the responsibility of those rights that you have now taken away. So this kind of goes through those and what your duties are, the things that you are now responsible for handling. Guardian of the estate, like I said earlier, is more so dealing with finances. And we use the general term assets because you don't know who you're dealing with. Like I said, it might be your child turning 18. And hopefully in that situation, you can avoid this. There's really nothing in their name individually. You might be dealing with your 28-year-old who just had an accident or who something came up later on down the road. So there's a spectrum of what you're dealing with here. So if you're dealing with a guardian of the estate, there are certain things that are different than with a guardian of the person. Like I said, generally with a guardian of the person, it is a much more simple and straightforward process. With a guardian of the estate, there are some different steps that have to be taken. Now, one thing that I will go back to on guardian of the person versus guardian of the estate. The first thing that is different is a requirement for a bond. So this is the first place where your cost, your actions are going to become different, because with a guardian of the person, you may be required to post bond. So I always use Austin as an example, Travis County, because that's where I mostly practice, Travis County and Williamson County. And those are actually two good examples because it's really different between those two counties. With Travis County, Judge Herman here is always going to require a parent, even in a guardian of the person, to get a $13,000 bond. Straight, no exceptions to that rule here in Travis County. A $13,000 bond, just to give you an idea, because I know sometimes people have questions on this. Do I have to give $13,000? No, it's a bond. It's essentially an insurance policy. So it's typically, you can get a lifetime bond, which means you buy that bond once, and so long as you are a guardian, it stays with you. Some places deal with annual bonds. It depends on the companies that you're working with, but on average here in Travis County, we use a forever bond is what it's called. So that $13,000 bond that will last you for as long as you are guardian is about $325 or $275. I think it's $275 is the last cost that we had. So that gives you an idea there. Now, Williamson County or smaller counties like Bastrop County around me, you might only have to put $100 down with the court. Some courts might not require you to post bond at all. So with a guardian of the person, there's a lot of variation depending upon where you live, what your requirements will be based on that court's practice. So if you're down in Houston, that might be different. I don't practice in that area, so couldn't tell you exactly what the costs are down there, but I would imagine that probably if you are in Harris County, it's going to be very similar to Travis County. If you are up in Dallas, probably pretty similar. Smaller counties, you're going to be dealing with more of, okay, maybe $100 cash bond, maybe nothing. It all depends on the court that you're within. That is very different than a guardian of the estate. With a guardian of the estate, it is a statutory requirement for the guardian to post a bond. And that bond is generally going to be based upon what is the value of the assets that you have control over. Now, I could probably sit here for 2 hours talking to you about ways to get around that, but you probably don't want to listen to that, and we only have an hour. So know that there are ways to get around or minimize the level of that bond. But if, let's say, in that scenario I mentioned earlier where the son had the accident, I mean, if he had $300,000 in assets that have to be managed, that guardian is going to have to get a bond for $300,000 or more. So again, it's a bond. You don't have to put $300,000 up. Generally speaking, depending on the credit, it might cost you between 2% and 4% of the actual value. It just depends on, again, where you're getting the bond, what your credit worthiness looks like, things like that. So that becomes a little bit more complicated. You're starting to kind of see, why do we want to avoid it where we can? We don't want to get into all of that if you don't have to. You have to do a physical inventory of everything that individual owns. It becomes much more court involved I don't want to say day to day, but more regularly than year to year, there are certain things that you will have to go back to court to get permission to do. It's not as though you become guardian of the estate and you just carte blanche become all rights to be able to do whatever you want with that individual's money. You have to provide basically a budget to the court. You have to provide what you think is going to be necessary. And if there are changes to those things, you have to go back to court to amend things. So as you can kind of see, if you're guardian of the estate, you're going to be much more intimately involved with that court over time than if you're just a guardian of the person, where you still have the right to make all the physical decisions for the individual, but you are only having to report to the court once a year. Now, there are some things you have to report to the court with a guardian of the person if there are changes, like if you move, if there's a necessity for your child to go to a more restrictive, like a housing a facility, you have to report things like that. You still don't have carte blanche right to make every decision without the court as a guardian of the person. But for most people, you're not going to have to go back to court to make decisions. So I'm just going to go back here because I noticed there were a couple more questions that came in. So the first question we had is, what if mom has guardianship, but now is in a state hospital and dad does not have guardianship? How can he get guardianship if mom is now incapacitated? This is just really a hard situation. So I will preface this by saying you're probably going to want to have a more one-on-one conversation with an attorney based on the circumstances. I'm not entirely clear with your question if there had been a guardianship over mom or if mom had guardianship for someone else. But you don't get guardianship unless someone is incapacitated. So if mom is in the state hospital needing guardianship, someone needs to go to court to get it. The other question that we have here is, what if the county that you live in doesn't have a probate court? How is the guardianship different? It is really not different at all. You're in a different court. Okay, so even though you don't have a probate court, you still have to go to court. Now, there might be a difference in formalities. To kind of give you an idea, here in Travis County, really formal, you are still in a court setting. You are going before Judge Herman. You are at the bench, very similar to what you might see on TV if that's been your only experience with court. I've had cases in smaller counties where you're literally in the judge's office. So that is going to be different. The process in terms of having to put in the application, things that you see on this slide ahead in front of you right now. So having to get a physician certificate or some kind of doctor's statement, those are all built into the law. So that has to happen. You have to do the application. The application goes into the court. You include that physician certificate, or depending upon what the situation with your child is, it might not be a physician certification so much as it might actually be a determination of intellectual disability report. So if you've had they're commonly referred to as DIDs. If your child has ever had a DID, if there's been one within the last 24 months before they turn 18, you can use that to get the guardianship. But you need one of those things to start the process, because that's where they are going to be able to tell the court that you actually need it. And then that starts the ball rolling. So you'll see a difference in terms of, like I was saying, the cost of bond, and you'll see a difference in the formality within that court, depending upon where you are. But the statutory requirements are still the statutory requirements, no matter where you are.
And Melissa, we have some clarification on that previous question, that mom had guardianship over the child, but now she is incapacitated. Dad wants to get guardianship over their child.
So in that scenario, dad is still going to have to go to court. Thank you for the clarification on that. So when someone has guardianship over someone else, and then the person who holds the guardianship becomes incapacitated themselves, the court is still needing to be involved in transitioning that power to someone else. So dad is going to want to, if there was an attorney involved in the guardianship, I would recommend they reach out to the attorney that helped them in the first place, or reach out to the court to find out in their area what they need to do, who they should contact. Generally speaking, I'm always going to be preferential to contacting the attorney who did the case in the first place. So generally speaking, for parents, you are going to be able to act as guardians. So there's this thing in the law where basically it's saying you can't be disqualified. So they love to work in the negatives. It's not that this is what it takes to be qualified. It's you just can't be disqualified. And these are the things that it takes to be disqualified. So clearly a minor is not going to be able to get guardianship over someone else. They don't have the legal capacity under the law, and if they're a minor. This is always the one that gets me. So you will oftentimes hear people say, if you are a felon, you can't be a guardian. That's generally true. That's not actually what the law says. What the law says is a person of notoriously bad conduct. So that is left open to interpretation a little bit. I think everybody is on the same page that if there is a history of felony charges and actual convictions for the person, then yes, they're not going to be able to be a guardian, but it could extend beyond that. So it might be a ton of misdemeanors. That doesn't necessarily mean that they're a felon. There has to be a provable history of unseeming conduct. Clearly, if the person is incapacitated, if you've got a lawsuit going on between you and the ward, clearly that's not a good idea for the court to appoint you to be a guardian over that person. Doesn't really seem fair. If the person is indebted to you or you are indebted to the ward, those are all things that's going to disqualify you from being guardian. Now, the other thing that I will step and say here, which is always a common question, co-guardians. Technically speaking, co-guardians can be appointed. So this is again where we get into matters of the legality under the statutory rules versus practicality in the way that the courts work. And I will use Travis County as an example. Here in Travis County, they will only appoint co-guardians if they are the married parents of the individual. So if I had a child who was turning 18 and needed guardianship, and my husband and I wanted to become co-guardians, we could become co-guardians. If my husband and I were divorced, they are not going to appoint the two of us co-guardians. Okay. Or if we've got like auntie and aunt spouse, they're not going to appoint aunt and aunt spouse. They're going to appoint aunt. Now, generally speaking, as an estate planning attorney, I'm going to recommend anyway, you don't want to name in-laws when you can do what's called a declaration of guardian for your children. That's where you get to say to the court, if somebody needs to act as guardian for my child, these are the people that I want to act for them. As an estate planning attorney, turning off the special needs side for a second, I'm always going to tell clients not a good idea to name in-laws. You may love them. Some of us have in-laws that we would take over our actual family any day. That's fine, but it's a bad idea. Because unfortunately, even the best of relationships, you never know what can happen. And if you name an in-law and there's a divorce, things can get really ugly and you may not want that person anymore. So always err on the side of caution. You're going to name your family member, the friend. You're going to pick the one person you really, really want to be there. So we've talked about these a little bit earlier. These are those kind of less restrictive alternatives. So the first few things here, those highlighted items, these are the most prevalent things that you can do relatively quickly and easily. So durable powers of attorney. Durable powers of attorney are financial powers of attorney. That's where if your child, when they turn 18, now they cannot sign it until they turn 18. So it has to be their 18th birthday or later. But if they have the basic understanding of what it means to give someone the authority to sign legal documents for them, to manage their money, to pay their bills, etc., they can sign a durable power of attorney that will give mom or dad the ability to help them do that. They can sign a medical power of attorney so that you can tell the doctor what to do when when your child doesn't have the ability to tell the doctor what to do, which stick a pin in that. We're going to come back to that in a minute as well. HIPAA authorizations to tell doctors who they can share with, medical directives, living wills, life support. So kind of your basic medical and financial documents that everybody should have. Okay. Now, I mentioned earlier, you could do joint bank accounts, but then you could also do like a rep payee. So a rep payee, if you are obtaining Social Security for your child, you can become the rep payee for Social Security. You don't need to be guardian to be a rep payee. Guardianship management trust, that's more so dealing in special needs trust. That's more so dealing with what I mentioned earlier, where there are ways to lessen the bond that would be required if you had to get a guardian of the estate for someone. These are ways to deal with the money that that person already has. Pre-need designation of guardian. So I think I saw a question in there that said, what was that called? A declaration of ? It is a declaration of guardian. So whenever we're doing estate planning for clients, you're always going to have, if you have children, let's say, if you have minor children, you're going to have 2 declarations of guardian. You're going to have a declaration of guardian for yourself, saying, if something happens to me, this is who I want the court to appoint. And if there's someone that I don't want the court to appoint, this is who you're not allowed to appoint. And if you say that, they cannot appoint those people to make decisions for you. And then you're also going to have a declaration of guardian for your children. Same thing. You're telling the court, if something happens to me and someone needs to act as guardian for my child, this is who I want. And generally speaking, unless the person's otherwise disqualified based on those things we talked about earlier, the court's going to go with your wishes. They want to go with your wishes as much as they can. So long as the people that you choose are willing and able and not disqualified from doing so, the court's going to follow your wishes as much as they can. Now, the big one, like I said earlier, supported decision-making agreements. I said earlier too, we wanted to stick a pin in the medical power of attorney issue. There's a really big disconnect with medical powers of attorney. And they're important. It's an important distinction between medical and financial powers of attorney, because with a durable power of attorney, a durable statutory, your financial power of attorney, that document is going to give you the right to make decisions and manage accounts for the principal, your child, right away, as soon as it's signed. They can have complete capacity, complete ability to make their own decisions, and you still have the ability to help them. With a medical power of attorney, I said something that was really key. You can only make decisions under a medical power of attorney when your child is not able to make them for themselves. So you don't have the right to override what they want. You don't have the right to tell them what to do. And most of the time, we don't want to tell them what to do when we're going this route, because the idea here is you don't have to tell them what to do. They still need help, though. That is where supported decision-making agreements come into play. Supported decision-making agreements are agreements, they're contracts that are signed between the child or the individual, the principal, and parents, aunts, uncles, whomever it is that they want to be the one to help them make decisions. That's the key. Supported decision-making agreements still don't allow you to make the decision, but they allow you to have all the information that you need to help your child get to the right decision for themselves. So with supported decision-making agreements, there's a lower level of capacity that's necessary for your child to be able to sign those, meaning when we're looking at capacity, there's levels of capacity. And for some things, you need more capacity than others. So what usually shocks people, for example, is signing a will. Signing a will is the lowest level of capacity that anyone would ever need. You basically need to be able to know who your friends and family are and a general understanding of who what your assets are. It's pretty low level. Then you have more your higher level capacities like contractual capacity, which you have to have a pretty good understanding of what you're signing and what you're giving away and what your rights are. There has to be a good meeting of the minds is the term that we use. With a supported decision-making agreement, it's much closer to the will level of capacity than it is to the contractual level of capacity. So a lot of people actually do have the ability to sign a supported decision-making agreement, which now that in conjunction with a HIPAA authorization is going to give you the ability, because basically your child has signed a contract saying, I want help and I want this person to be the one to help me. So by doing that, in being able to do that, I want this person to be able to talk to everyone that they need to gather the information to help me make the right decisions. Again, you still don't have the right to override what their choice is, but for a lot of families, it's sufficient to get where we need to be to really help your child live a more independent life, avoid having to take those rights away that may not be necessary for a lot of people. Now I'm going to stop for a second because I've noticed a couple of other questions come into the chat.
Melissa, I was going to stop you too. Is there an educational power of attorney?
So with an educational power of attorney, I would recommend a supported decision-making agreement. So the medical power of attorney going back is going to be for medical information. Durable power of attorney is generally speaking going to be for finances. But if you do that supported decision-making agreement, That's what's going to allow you to get information from the school and talk to them and get information from them. Because that supported decision-making agreement, it kind of takes a more holistic view on things. So you've got medical over here and you've got financial over here, and then you've got your supported decision-making agreement, which takes the entire span between the two and gives you the right to get information and help with making those decisions across the board.
The next question says the highlighted alternatives are the easiest to obtain. I think the highlighted points here are the alternatives to guardianship. Is that correct?
Yeah, so all of these are different alternatives to guardianship, depending on the case. Now, Katie's Law, community administration, those are more so for your elderly, if you've got elderly parents you're dealing with. But these are all things that can be done. The highlighted ones, I would say, yes, they are generally speaking the ones that you can do most easily. And they are, the reason I highlight them too is they're the ones that I recommend going to first, because they're going to be the most productive for you.
Okay. Can your child with an intellectual disability sign the supported decision making if they might not understand it?
So that's where you get into a little bit of gray area. For me, I'm really careful with clients. Most attorneys, most of my colleagues like myself, we have a fine line to balance between needing and wanting to do everything we can to help the situation and help your child maintain as much independence as possible. But at the same time, we need to also consider, do they actually have the ability to understand? So it's a really fine line. And sometimes it does get to the point where we have to err on the side of caution as an attorney. So I have had people, I'm not going to say I recommend or don't recommend it. I've had people that have just signed supported decision-making agreements, and then later on they come in and they've worked out. But speaking as an attorney, it's a very fine line for us to balance, because guardianship attorneys have a very different type of relationship with clients. Like if you go to an attorney to deal with a personal injury lawsuit, or generally just being to do your estate planning, that attorney is representing you and only you. When you're dealing with an attorney that's doing guardianship work, yes, that attorney is representing you in your capacity as the potential guardian, but we also have an obligation and a duty to do what is most protective for the potential ward. So it's a fine line, and sometimes you'll see that attorneys like myself are going to err on the side of caution because of that.
Okay, and then the last thing here is if we sign a supported decision making and then we change the daughter's last name, do they have to redo it, or is it still okay?
So like most things, it would still generally speaking be okay. So I get clients on the estate planning side all the time. Oh, we did our estate planning 3 years ago. My daughter got married, she changed her name. Do we have to redo our documents? No. That document clearly identified who your daughter was at the time that it was signed. Now, if it's easy enough that you can just re-sign one under her new name and she still has that minimal capacity to sign it, probably best to do that just to make everyone's lives easier in case you start dealing with new people, not having to deal with AKAs and things like that. But generally speaking, you don't need to change names when someone has a name change, because you're just identifying who they were back to when they signed the contract.
Okay, those are all the questions we have for now.
So going back into supported decision-making agreements, you don't have to read all this code if you don't want to. It just kind of gives you a good rundown of what the idea with these supported decision-making agreements were. And what, like I was saying, it is a really good stopgap and actually very helpful for like the person who asked about educational powers of attorney and things of that nature. This kind of fills that gap between, okay, it's not really a medical decision, it's not necessarily a financial decision, we don't have guardianship. What allows us to help? This, because this allows you to talk to the school, talk to therapists, talk to everyone that you need to talk to help your child make those decisions. So in terms of who can sign one, so anyone over the age of 18 can sign one if there is a need to, is generally what this is saying. So there has to be an impairment that substantially limits one or more major life activities. This also is, like I was saying, the level of capacity that a person has to have. While it's not defined, it has generally speaking been held to be a very, very low level of capacity. So they have to understand the nature and the consequences, but they're not signing off rights to anyone. They're allowing you to help. So that's going to minimize the need for higher levels of capacity. And like I said, really different than an actual power of attorney, because it's not giving you rights to make decisions for them. It is giving you the ability to help them make their own decisions. So it's you continuing to act as a guide and letting them have a little bit of leeway to make that decision for themselves, and understanding that you may guide your child one direction, and if they don't make the exact decision you want them to make, just like any other 18, 19, 20-year-old child who's off in college, you have to live with that. So this goes through again what it does and does not allow for you to do. So again, it allows you to help make decisions. It allows you to collect information, assist your child in assessing it, and guiding them towards what they should do in the scenario. So like I said, this might be, it even extends to employment. Where does your child want to work? You can have involvement in that. You can have involvement in school. The big thing is that this does not, so a power of attorney, a durable power of attorney does, and a guardianship does create a fiduciary relationship. Michelle has a fiduciary relationship with her clients. I have a fiduciary relationship as an attorney with my clients. What that means is I have a duty and an obligation to act in that client's best interest and always put myself in the situation of doing what is in their best interest and not in my own. Now, not that you shouldn't do that as a person under a supported decision-making agreement, but it doesn't technically create a fiduciary relationship. What that actually means for you is there's no course of action that can be taken over you. So someone can't sue you for guiding your child to the wrong decision or whatnot. Or if your child decides not to make the decision that you have no obligation, you have no duties to them. So there's not that fiduciary relationship under this. Whereas there would be if you were financial power of attorney for someone and mismanaged their funds, or you embezzled something, not that any of you would do that. Yes, you will be held responsible for that. But in here, it's a very different standard. So going back to kind of the first initial questions that we went through, things that you need to think about if you're going towards, do I need a guardianship? So as your child is getting closer to 18, you want to look through and think about these things. Now, the question I get many, many times is, when do we need to start the process for guardianship if we determine that it's going to be necessary? So the sweet spot is usually within 6 months prior to your child turning 18. And I say that because even the easiest of guardianships can take a while to get to the hearing. Now, you're not going to be able to have a hearing until after your child's 18th birthday, but between having to get your physician certification, going through the application process, when you submit the application, the court then appoints an ad litem, which is another attorney to represent your child, who then has to interview your child. That can take a while. To put it in perspective, the longest guardianship I have had thus far, which was uncontested, child turns 18, married parents trying to get guardianship, it took 9 months from beginning to end between trying to get the ad litems. Now, granted, this was kind of in the heat of COVID, so we'll give a little grace on that. But it can take a while. So you don't want to, if you're trying to get the guardianship in place as soon as possible after the 18th birthday, you want to start about 6 months prior to the birthday. But you need to make sure that you can no longer make decisions for them legally. Okay. You need to make sure that the doctor is saying that it's going to be necessary. So that's the first step. Most counties utilize the same form for their physician certificate. And if you wanted to see what that looks like, you can actually get it right on the Travis County Probate Court's website. But it's a pretty straightforward, it's about 4 pages that typically, depending upon the scenario, primary care physician, or if there's a neurologist or something like that in play, a specialist might fill it out. But if that's the case, you want to start at that point in time. Now, I mentioned a little bit of information. I always like to throw a tidbit just in case, because some people, you're sandwiched. You're dealing with your kids and your parents at the same time, which is hard. That's a lot of work, but it kind of gives you a little bit of information, things to think about for your parents if that's necessary too. So what do you do from here? Okay. So before I go here, I'm just going to see here, we had a couple of other questions come through. So there was a question from Emily, does the supported decision-making agreement allow you to speak to doctors? Your supported decision-making agreement is going to be accompanied by a HIPAA authorization, which is going to allow you to speak to doctors. So it's technically the HIPAA that combines with the supported decision-making agreement that allows you to speak to doctors, educators, so on and so forth. The next question that we had was from Ryan. If I have I'm guessing power of attorney or a supported decision-making over my child, can they not participate in their ARDs and I make decisions for them, or do they have to be there no matter what? So you've got a look on your face, Michelle.
I'm trying to understand the question. Can they not participate? I mean, wouldn't you want them to participate?
Yeah, so if you have a supported decision-making agreement, you still have the right to speak with anybody that you need to speak with, and you don't get to be the one to make the call, because you're saying when you have your child sign powers of attorney and supported decision-making agreements, you are saying they don't need a guardian. They have the ability to make these decisions with help, but they have the ability to make these decisions for themselves. So generally speaking, you're going to continue in those, but it's up to you and your child to do that together.
That makes much more sense.
And then how do we get the HIPAA paperwork? So generally speaking, call me biased, I'm going to tell you your best course of action is to speak with an attorney to get everything in place and make sure that you're doing the right thing that you need to have for your child. And then good, you've got the supported decision-making agreement already. There are some really great community sources as well. So there are, help groups, support groups from all different areas in terms of whatever your child's condition may be that you can locate, and they can also help you with some things as well. But I would recommend speaking with an attorney about most of this stuff to make sure that you're on the right path. But going through all of the a HIPAA authorization. So the question was, what was it called? A HIPAA agreement? It's a HIPAA authorization is what you're looking for. So your options moving forward with your child. So again, start thinking about these things, 6 months to a year prior to your child turning 18, start the process if necessary for guardianship about 6 months in advance. If you have aging parents, talk to them, make sure they've got a plan in place, make sure they've done all of their estate planning before they get to the point where you're going to have to do these things for them. Make sure you've got a good estate plan in place, because what happens if something happens to you? You want to make sure you've got all your ducks in a row. You want to make sure that you've got a good estate plan. If you've got a child who's going to need Social Security and Medicaid into their adulthood, you're going to need to make sure you've got the proper special needs trusts in place. Maybe you need to open an ABLE account if you haven't done anything yet. That's a good thing to talk to Michelle and Allison about. So you want to make sure you got all your ducks lined up. Okay. And then where it's possible, you may want to consider a supported decision-making agreement when guardianship is not going to be necessary. If anyone has any other questions, this might be the first time in history that I am just under the wire. Have time for questions.
Yes, so we have a couple more slides for consolidated planning groups. So let's go through those while you put your last few questions in the chat box. If you don't mind, Melissa, there's just a couple more. We'll skip this one. We have a lot that we talk about, and we help families every day with so many different topics. So this link will be clickable when you get these slides later on today, and it will take you to our upcoming webinars on our consolidatedplanninggroup.com website. So you'll be able to click that link later on today. The next slide should be our Meet the Team. We are here for you. Like I said, we work all of Texas, all across the United States. One thing I want to mention as you're looking at all of these smiling faces is that because you registered for today's webinar, we are going to reach out to you to see if you have either any additional questions for us or for Melissa, or if you would like to set up a free initial consultation. So please don't be rude to our staff. Our operations staff are going to be calling you. Look at those smiling faces. You don't want to hang up on them. We're just doing our jobs and we're just here to help. And on the last slide, if you would like for us to not call you, the best way to have that happen is to go ahead and sign up for your free consultation before we call you, and then we don't have to. You can use the QR code. You can call us at 281-690-1177 or email us at contact@cpgcares.net. You can follow us on our YouTube channel, which is where all of our webinars live. There's our Instagram channel, our podcast, and our Facebook page. And again, if you're listening on the podcast, feel free to email us, contact@cpgcares for a copy of the slides. That's all I have to say. So back to you, Melissa, to answer this last question or two.
So we had one last question come in from Wendy. What happens if you and your husband are guardians for your child and the parents, you and your husband, I would presume, are killed in an accident? What would the process be for the sibling or another family member to be able to become guardian? So this is going to be similar to what we had mentioned earlier. So if you are the guardians of an adult disabled child and something happens to you, incapacity or death, then one of the other siblings, now if you had done in your estate planning a declaration of guardian for your incapacitated child, you're going to have a document that tells the court your preference. And hopefully the person that you put as your preference is the person who steps up and wants to do it. So let's say it's Johnny. You can tell I like the name Johnny for some reason when I talk. Johnny is the sibling. Johnny's going to become the successor guardian because something has happened to you. Johnny's going to have to put in an application to the court again. So there will be more court action that is involved because anytime there's a change in guardian, the court has to do a full investigation over who is going to become the new guardian. So it's a similar process, a little bit condensed because there'd already been guardianship in place. So they're not having to determine that the person is incapacitated. They're having to determine that the person who's trying to become guardian is qualified to do so. So it's a little bit of a condensed practice. It's a little bit of a condensed time frame on what has to happen. In terms of what happens to the child during that time, I mean, that is a very loaded question as to what circumstances are we talking about. So I sorry, don't have time to get into all of the permutations today, but what I can generally say is, generally speaking, while that process is ongoing, doctors and individuals that have to work with you typically are going to give grace. Is there a chance that they're not going to give grace because you just get that person? Yes, that's always a chance, but that process is going to need to start as soon as possible. So you need to make sure, this is another thing going back to, the community around you. And I'm guessing that probably you've done this already, but it's really important that you understand what kind of involvement in your other kids understand what is required and are they willing and capable of handling it. There are some scenarios where it would take heaven and the other place to get a child to act as guardian. And then there are other ones where it would take heaven and the other place to get them to not act as guardian. So it's really important that you're having these conversations with the adult sibling when you have a scenario where you have guardianship over an adult child. Because I have, in my opinion, the world's greatest paralegal who has been the guardian for her sister for over 30 years. And if you ask her, nothing was going to stop her from being guardian for her sister at that time. But if I've got, kids in their 20s and I've got a 24-year-old child who's potentially looking at being guardian for my other child and they've got a lot going on, that might not be best suited for them. So it's really important you're having these conversations with your kids up front.
Thank you again, Melissa, and to everybody who stuck with us for the hour. I hope you got some nuggets of wisdom that are going to be very helpful for you. We look forward to hearing from you again soon. And if you have any further questions, like I said, feel free to reach out to Melissa or me. Our contact info is in the chat. You will get an email later today with all of this Have a great day and enjoy the rest of your week, everybody.
Thank you for
Bye-bye.
joining us.